$15. That's it. That's what cost Natasha Knox her job, the cost of her cab ride to work. And it raises the bigger question, was this really about $15 or was it about discrimination? Today we are talking about Knox v. CRC Management, a case that started with just $15 and ended up testing how employees can prove discrimination in court. So by the end of this video, you will know the story of how a $15 cab ride became a discrimination lawsuit, what comparator evidence really means, and how employees can actually prove discrimination at work. And if you're an employee going through discrimination right now, you'll definitely want to stick around for this one. And if you're a small business owner or an HR professional, this case is a reminder that you have to take employee complaints seriously. That means investigating complaints promptly, documenting what employees report, recording your investigation steps, and keeping track of the corrective action you take afterward. Because when you don't, the employer could face serious legal consequences. I've created a lot of resources on this channel to help you with that, from compliant harassment training videos to free quizzes, sample policies, and even my harassment investigation workbook. I'll post a link for you below. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider, and on this channel, I do more than share legal opinions. I break down real cases to show how the law might apply to your workplace, whether you're an employee trying to protect your rights or an employer trying to do things the right way. If you've seen my other videos, you already know the workplace can be full of unfair and downright toxic situations, but here's the challenge. When employees finally take a stand, their cases are often dismissed as if they don't matter. That's why today's case is so important, because workplace discrimination cases happen all of the time, but the hard part is proving discrimination. That can feel impossible. One of the biggest questions employees often ask is, how do I actually show I was treated differently? The answer often comes down to something called comparator evidence, proof of how other employees were treated in the same situation. In today's case, it's the perfect example. Okay, let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. On December 17th, 2018, Natasha Knox, a Black woman of Jamaican descent, was hired as a customer service attendant by CRC Management, a wholly owned subsidiary of Clean Right Centers. Now, Clean Right is no small operation. It's one of the largest laundromat chains in the U.S., operating under its parent company, Laundry Capital. Laundry Capital was founded in New York in 1996, and the Clean Right Centers brand launched around the year 2000. Today, Clean Right operates more than 70 laundromats across states like New York, Ohio, Maryland, Pennsylvania, and has developed over 200 stores in total. Now, the company was founded by Alex Weiss, who still leads the business. Clean Right is privately owned, and its exact value isn't public, but it's widely considered the largest retail laundromat company in North America, and its workforce is predominantly Black. Now, on her first day, Natasha signed a notice of acknowledgement of pay rate and payday. Then, just a few days later, on December 21st, 2018, Natasha Knox began working at Clean Right Laundromat. She typically worked 4 shifts per week, 2 shifts from 8 a.m. to 4 p.m., and 2 evening shifts from 4 p.m. until midnight, so about 32 hours a week. She also picked up an additional 8 hours at 2 other Bronx locations. Her pay was $15 an hour, with $15.50 for overnight shifts and $22.50 for overtime. Her duties included greeting customers, washing and folding laundry, keeping inventory, and cleaning machines. Within the first month, she received the company's employee handbook and agreed to follow its policies. In late January or early February 2019, Knox broke her thumb in a car accident outside of work. She told her supervisor, District Lead Vincent Butler. Butler instructed her to avoid heavy tasks and focus on lighter duties until her hand healed. But February also brought another challenge. Knox says her colleague Cecilia Ashmead, also a black woman of Jamaican descent, began harassing her daily. According to Knox, Ashmead told her she was too hood and too ghetto to work at Clean Right, and once remarked that the Yankee in her made her timid. Knox reported this to Butler by the end of February, but before any meeting could be held, Butler left the company. Then, on March 5, 2019, Knox missed work for medical treatment. Her doctor restricted her from lifting more than 25 pounds. She claims she told Ashmead the next day, asking for an accommodation. Ashmead allegedly responded that she shouldn't have this job if she couldn't lift. Soon after, Knox received a text saying she would be removed from the work schedule, though she continued reporting to work. On March 11, 2019, Ken Ferris replaced Butler as district lead. Knox told Ferris that she needed lifting accommodations, and he acknowledged that limited accommodations were already in place. 2 days later, on March 13, 2019, Knox contacted District Manager Neville Baptiste, claiming racial harassment and failure to accommodate her thumb injury. She says Baptiste asked for a doctor's note and told her they might need to have a conversation if she couldn't do her job. By mid-March 2019, Knox alleges that Ferris himself began making discriminatory remarks about her and to her. She says he told her she looked like Aunt Jemima and mocked her for talking Jamaican when she was upset. On March 25, 2019, Knox met with Ferris to discuss harassment and missing wages. She also claims she filed a formal complaint about unpaid hours worked at the other Bronx locations. Ferris admits they met, but says they only discussed pay. Knox alleges that some of her hours were whited out on the timesheet and credited to Ashmead instead. Ferris and Baptiste later concluded, after reviewing records, that Knox was fully paid. But Knox insists that she never received a response about her complaints. Then on April 5, 2019, Ashmead was replaced by Ashley Peguero as team leader, and Ashmead was transferred to another location. On April 6, 2019, Knox again reported unpaid hours to Peguero, who raised the issue with Ferris. Ferris responded that the matter had already been investigated and resolved. Now comes the event that ultimately cost Knox her job. On April 14, 2019, Knox took $15 from the laundromat's register to pay for a cab ride to work, leaving her receipt behind. She later testified that Ferris had given her permission to do this as long as she left a receipt. The next morning, April 15, 2019, Peguero noticed the missing money and the receipt. Security footage confirmed that Knox had taken it. When confronted, Knox admitted taking the money and said this wasn't theft at all, because at Clean Right, employees considered the money in the register to be petty cash. Practice was simple. If you needed a cab fare, you could take the money as long as you left a receipt so the manager could replace it later. In fact, Knox says this happened regularly during her time there, sometimes with supervisors even paying directly out of the register. So when she reimbursed herself $15 for a cab, Knox believed she was following that same practice. And her point was other employees did the same thing without getting fired. That's comparator evidence, and it goes directly to proving discrimination. Now, when we talk about comparator evidence, what we mean is this: looking at how other employees were treated in similar situations. So a comparator is another employee who is similar situated to you. They have the same job, same rules, same supervisors. If they broke the same rule or did the same thing you did, but the company treated them more leniently, that difference can be powerful proof of discrimination. In other words, comparator evidence answers the question, was I treated differently than others who were basically in the same shoes? And if the answer is yes, it can show the employer's reason for disciplining or firing you wasn't the real reason. On April 18, 2019, Ferris terminated Knox's employment. The official paperwork cited theft and insubordination, specifically taking cash from the register and refusing to return it. Knox's employment lasted exactly 4 months. And just over a year later, on May 27, 2020, Knox filed a lawsuit in federal court alleging race and national origin discrimination, hostile work environment, retaliation, failure to accommodate her injury, and unpaid wages. In its response, Clean Rights said that Knox got it all wrong. They said she was fired for theft and insubordination and pointed to the handbook, which says theft of any kind can result in termination. They argued no one else was ever allowed to take money from the register, so there were no valid comparators. Clean Right flatly denied that any of the racial slurs or offensive names Knox described were ever used in the workplace. They argued these were either never said or even if they were too isolated to legally qualify as a hostile environment. And regarding her claim of hostile work environment, Clean Right said that Knox never reported harassment, only wages, and her firing was strictly about taking $15 from the register and then refusing to return it. Clean Right also argued that Knox never formally asked for an accommodation. In fact, they argued she was already being given lighter duty, claimed her firing had nothing to do with her injury, and those unpaid wages that Knox said she never received, Clean Right said they investigated and found that she was paid for every hour she worked, including overtime. In January 2023, the district court sided with Clean Right. It said Knox's testimony was just self-serving and not enough to survive summary judgment. But in April 2025, the Second Circuit Court of Appeals reversed that ruling. And the appeals court made it clear sworn testimony is still evidence. When you have disputes about comparators, harassment, or credibility, those issues belong to a jury, not a judge. In other words, Knox's case lives on, and it will be up to a jury to decide whether Clean Right's reasons were legitimate or whether it was a pretext for discrimination. So let's talk about how you prove discrimination at work. The law uses a framework called McDonnell Douglas burden shifting, and it works like this. The first step is that the employee makes what's called a prima facie case. That simply means they show three things: that they're part of a protected group, that they were qualified for the job that they had, and that they were fired or disciplined. Now, when the law says you have to show you were qualified, it doesn't mean you were perfect or the best employee. It just means you had the skills to do the job and that you were performing well enough that your firing or discipline can't be blamed or can't be explained away by poor performance. That way, the focus stays on whether the employer's reason was really discrimination. What happens next is really important. The employer offers a legitimate reason for the action, here the alleged theft of $15. Then the employee must show that that reason is pretext, meaning it's not the real reason. If coworkers did the same thing under the same rules and they weren't punished, that's your evidence that you were treated differently. That's how comparator evidence can prove discrimination. Knox testified that other employees also took taxi fare from the register and weren't disciplined. This creates a comparator, same job, same act, different outcome. That's why the appeals court said this case can't be thrown out at summary judgment. A jury should decide whether the firing was really about theft or whether it was about discrimination. Here's the takeaway. If you're facing discrimination, document your situation and look for comparators, people who were treated differently under the same circumstances. That's one of the clearest ways to prove discrimination in court. Discrimination, it can be difficult to prove in today's society because so much of what happens is indirect. Just like what we saw here, they called Natasha names, but the company insisted she was fired for theft, not discrimination. But this case shows that there is hope because the appeals court vacated the district court's summary judgment. Basically, the dismissal without a trial and reinstated Natasha Knox's claims against Clean Rights Centers. Now the case is still pending, but the fact that the court is willing to let it go to trial says a lot about the documentation and evidence Natasha was able to present. If other employees did the same thing, like taking cab fare money, but kept their jobs while Natasha Knox was fired, that difference can reveal whether the company's reason was just a cover story. Comparator evidence is one of the strongest tools that employees have to show
what's really going on.
This case isn't over yet, and I'll be keeping a close eye out. As soon as there's an update, I'll bring it to you here on the HR Insider, so make sure you hit that like button and subscribe so you don't miss the follow-up. This is Harlow for the HR Insider. Thanks for watching today. I'll see you in the next video.